Hello everyone, welcome to the 5th class on interview current affairs. Today we are going to discuss the recent demonetization verdict by the Supreme Court. So what Supreme Court has said that in a split judgment of 4:1, Supreme Court said that the 2016 Government Act of Demonetization, that is banning the 500 and 1000 rupees notes, that is well within the constitutional as well as legal limits. Being said, Justice Nagaratna put a dissenting judgment against the majority view. So what we're going to do in today's class is, we're going to see different arguments put forward by the petitioners against the Demonetization Act and what were the counter arguments by the government, and we'll analyze different majority view of the Supreme Court and the dissenting view. Let's get started. So what Supreme Court does here is, the whole petitions against the Demonetization Act has been clubbed into one case and 6 different legal questions has been framed, and answer to these were analyzed by different submissions. If you want, you can read this, pause the video and go through these ones. So let's get started. The first question. Here, what is the legal question that is being asked? So RBI Act, section 26(2) of the RBI Act, it does give central government the power to declare any series of bank notes of any denomination illegal tender. So central government does has the power. The question here is whether the any used under the RBI Act, does it mean to specific set of notes? Whether the central government has the power only to declare a certain series of notes as non-legal tender or illegal tender, or whether it applies to whole set of, whether the power is enough to carry out an exercise of massive scale, but like declaring all the notes as illegal tender like the Demonetization Act. So petitioners argue that this power is not enough. Here any cannot be taken as all. Any means it applies to only certain set of series that can only be declared illegal by a government gazette. If an exercise of the volume of demonetization has to be carried out, it has to be carried by an act of parliament. That was the argument put forward by the petitioners. Now, what was the Supreme Court judgment on this? Whatever the any or all or every, whatever the legal technicalities underlying, purposive interpretation has to be given to the law. That is, whether the purpose of the act or law is being considered, whether declaring the legality of it. So in this case, if a certain set of series of note has been declared illegal tender, then it in one way or the other it ends the whole purpose of demonetization exercise itself. So in this case, Supreme Court has given an interpretation as all. The central government has that power. On the other hand, the Justice Nagaratna came up with a dissenting view. That is, if the word any could mean all, it would confer excessive and arbitrary powers to the RBI. Legislature, parliament is giving certain power to the RBI to manage currencies, to conduct monetary policies under the RBI Act to the RBI. Now, if this under these powers, the powers like excessively taking back all the currency, that power is also granted to the RBI. That goes beyond what is the legislative requirement. That was the view of Justice Nagaratna. Then if such an excessive power has to be exercised, that can only be exercised through parliamentary legislation, not through a gazetted notification as done in the case of demonetization. So that was the different perspective on the first case. Now let's look at the second question. Whether the power vested with the central government under the subsection which we have discussed now amount to conferring excessive delegation as such liable to be struck down. So this is like a continuation of whatever the discussion is we have done so far. So petitioners are arguing that RBI Act delegates much more power to the central government. Like RBI is given XYZ powers. Now RBI is delegating under its act the powers to another body. Now if the another body is having the power, the delegated power is much greater, that is the power equivalent to some action done by the legislature, then it is a violation of principle of excessive delegation. So it should be struck down. That was the view of the petitioners. And what view the majority Supreme Court judgment was? Even though the law given excessive powers, or so it seemingly it gives so much powers to the central government, the law itself has inbuilt safeguards. And what are these inbuilt safeguards? That is, the central government is required to take the action like a demonetization only on recommendation of the RBI or RBI Central Board. So RBI Central Board is one way or the other taken into confidence within the legal aspects, legal system itself. On the other hand, there was one more argument to it. The delegation power in any case is given to the central government. The delegation power is not given to a lower body. It is given to central government. Central government itself is answerable to the parliament. So whatever the argument is that excessive delegation has happened, that has been countered by the Supreme Court. On the other hand, the dissenting judgment agrees with the petitioner's view. That is, the section 26(2) does give excessive powers to the center. Thus, if it is using its excessive powers, so the act should be declared unconstitutional. Now, there was one more debate to what is the purpose of declaring the act of after 6 years or 7 years. It's been more than 6 years. So what is the purpose of declaring the act unconstitutional right now? So this was put forward by the government. Anyway, whatever the consequences, positive or negative, that has to be happen, already happened. Even though Supreme Court today declares this unconstitutional, nothing much is going to change regarding what has happened. So what is the purpose of it? The counter by the petitioners was that even though whatever the negative consequences has happened cannot be taken back, the clock cannot be reversed. But at the same time, if it is declared unconstitutional, it gives a check on government on using excessive powers, in executive taking over the powers of other departments like legislature, RBI or judiciary. So there will be a check on executive in the future. So from future perspective, this case is very relevant. That was the argument put forward by the petitioners. Let's go ahead. So the next question, whether the in-punch notification XYZ is liable to be struck down on the ground that the decision-making process is flawed in law. That is, the decision-making process which is prescribed by the law is not followed. We'll start with the dissenting view or the petitioner's view, dissenting judgment. It was stated that like we have seen in the section 26(2) of the RBI Act, the government does has the power, but it can execute that power after the recommendation from RBI Central Board. So in this case, the decision of demonetization has not been originated from the RBI Central Board. It has been put forward by the central government. So this is a violation of section 26(2) of the RBI Act. On the other hand, there has been terms like as decided by the central government, as recommended by the central government. So one way or the other, it is conveying that it was a decision taken by the central government by itself and has been enforced on RBI. One more argument to this was RBI was given less than 24 hours time for taking the decision. Now if an organization is given less than 24 hours time, where is the time for applying independent mind? So this was also being questioned. So if this kind of an act, again, the government shows that it has to be done in a urgency and haste. Otherwise, the whole purpose of the act will go away. So still ordinance route was available. That was the judgment, dissenting judgment. Ordinance in the haste and quick implementation of the policy was still possible by following the Ordinance Act. And the case of Jammu Kashmir Ordinance, Jammu Kashmir State Reorganization Ordinance was put forward as an example. One day it was put forward before the parliament, it was passed in a day. So ordinance route was available. That was the dissenting judgment. Now what was the majority judgment? Merely because the process has initiated by the center, that is not a solid ground to declare the act unconstitutional. merely because government started it, government put forward the idea, that is not enough. You have to see RBI and government, at least in some cases, as a in cohesion. Further, minutes of the RBI has been put forward, and it says that the debates or discussion regarding demonetization has been going on for more than 6 months. Started from February of 2016, and some kind of discussion, consultation, all this were going on with RBI and government. So it's not something decision which RBI government has taken in one day and enforced on RBI on one day. Some kind of processes were going on. On the other side, there was one more aspect to it. Supreme Court said that during the submission phase, so it cannot sit with folded hands. If the simply saying that the policy is an economic policy and economic policy is a prerogative of the executive, by taking this argument, it cannot sit quiet by doing nothing. The judicial review, whatever is the applicable to other laws, does applies to economic policy also. But on the other hand, the effectiveness of the XYZ economic policy, that is not the matter of the Supreme Court. Whether the policy has been effective or not, that is the ban has been declared for XYZ reasons. Now, whether the policy has got these results or what are the results the note ban has came up with, this is not a concern of Supreme Court. That is being made clear by this majority view. Let's go ahead. Whether the impulse notification, that is the Demonetisation Act notification, to be struck down applying the test of proportionality. Now, this is test of proportionality is going on in news every now and then. You have seen it in Aadhaar case. In other cases also, the test of proportionality is being in news. Now, there are 4 ingredients to be satisfied for a law to be proportional, for an act of executive to be proportional. First one, there should be a legitimate purpose, and there should be a rational connection with the purpose. Whatever the government does for achieving XYZ purpose, the action and purpose should have some kind of rational connection, and necessity of the taking this action should be proven to some extent. And whether the action is proportional, that is there availability of any other XYZ measures which has lesser negative consequences, this has to be considered. Let's move ahead. So in this case, the majority view was that curbing fake currency, black money and terror funding, these all are legitimate interest of the state. So there is a legitimate interest or legitimate reason for demonetization exercise, and whatever the action government has taken have a rational nexus with whatever government is trying to achieve. So the second criteria is also fulfilled. Whether there is a necessity or not, this question is a purely economic question, and this can only be answered by RBI. If RBI can only answer this question, and RBI has not raised any argument concern against demonetization exercise, so this criteria also cannot be struck down simply by the legal jurisprudence. Now the fourth one, whether there is an alternative measure so that the same objective can be obtained. So this also cannot be ascertained with conformity. If government has done the XYZ thing, the same result may have been obtained without the XYZ harm. So this also cannot be defined with clarity. So under these circumstances, whatever the act the government has taken for demonetization does qualify the test of proportionality. So that was the Supreme Court majority judgment view. Let's go ahead. Whether now 2 small aspects of the demonetization has been contested. That is whether the 52 days that was given for changing the notes from old series to the new series, whether these 52 days is enough, or is this a violation of petitioners' fundamental rights? That has been put forward by the court. So court said that the Demonetisation Act is not the first time happening in the country. In 1978, a similar exercise has been carried out, even though the economic impact was much less. But during that time, 3 days time was provided. Today we have 52 days time for changing the notes. So it was unreasonable, unjust and violative of petitioners' fundamental rights. Like Supreme Court cannot find any much reason to prove that this days is unreasonable or unjust or violating petitioner's fundamental rights. So that was the view taken. Going ahead, whether RBI has independent powers, like some extension of 52 days is for normal people. For some XYZ cases, like people who have been in abroad, who came back to India after 52 days. So for such people, some extension has been given by the court. So this has also been, not court, RBI has given some extension for changing the notes for some people. So this has also been questioned by the petitioners, whether RBI has such right to give people the power or option to change the already demonetized notes. So what Supreme Court take on this regard was that RBI does has the powers. When there is a conflict between two law or two aspects of a single law, what you have to do is a harmonious construction principle has to be applied. That is the overall purpose or overall intent of the law has to be given precedence instead of taking it as a single case of conflicting laws. So RBI does has the power, XYZ powers, to give extension to this. Now that is the whole arguments put forward, all set of arguments in the demonetization verdict. Do work out this question. What are the legal issues contested in the demonetization case? Does demonetization exercise achieved its stated objectives? What is the relevance of the court declaring demonetization constitutional or unconstitutional 6 years after the exercise? Does judicial review applies in matters of economic policy? Do comment these answers. What is your stance on the matter? That's all for today. Thank you very much.